Welcome to another of NJAPM's webinars. Today's topic is the basics of New Jersey alimony and child support for new mediators and non-lawyer mediators. Our two presenters are Bruce Matez, who's been nominated to be president of NJAPM for the 2021-2022 years starting on October 1. Bruce is a lawyer. Roseanne Vanella is not a lawyer. And yesterday, we finished the 40-hour divorce mediation training course, which Anju Jasani puts on, and she gave her marketing presentation on the last day. Now, Roseanne took that course in around 2010, and I think she's a perfect example of how someone who really follows the basics can develop an excellent divorce mediation practice. So welcome to both of you. I'm glad to see both of you. We both worked together before. So with that, I'm going to turn it over to you with just the comment that they're going to be taking questions at the end of the webinar, their presentation. So please put your questions as you're going along in the Q&A function. And also we may ask people to raise their hands at the end. So with that, welcome, and it's yours.
Okay, thank you,
Carl.
Thanks, Carl. So the way that we're going to structure this is I'm going to do a review of the Alimony Statute, a review of the Child Support Statute, and talk a little bit about the Child Support Guidelines. We'll talk a little bit about software, Child Support Guideline software, and then Roseanne is going to talk at length about how she works with couples in addressing alimony and child support and coming up with appropriate numbers for her clients. And then I'll talk a little bit after she's done about the way that I do, but we pretty much do it the same way. So the first thing I'm going to talk about is the Alimony Statute. And I'm going to show you the statute in a minute, but I want to make sure that we talk about this thing called rules of thumb before we get into the statute. So everybody understands there is no rule of thumb for calculating alimony that is recognized in our body of law. There are a lot of lawyers and accountants and judges and mediators out there who think that there's a rule of thumb, and they've established what that rule of thumb is in their own minds. But there's no case, there's no law, there's no basis other than what people think it should be for these rules of thumb. And they go to both amount of alimony and duration of alimony. So we're not going to talk about these rules of thumb today in terms of that's how you should be calculating alimony, or that's how you should be deciding on duration. We're going to focus on the statutes and the guidelines. So the Alimony Statute, if you give me a second, I'm going to share that with you if I can. Nope. Carl, oh, there we go. Okay, hold on a sec. It was here a second ago and now it's gone. Oh, there we go. All right. Let's hope that worked. Can everybody see my, Roseanne, can you see it?
Yes.
Okay.
Yep, it's up on the screen.
Okay. So these are the statutory factors for determining alimony. There are 4 types of alimony in New Jersey. They're defined in the statute. Open durational is basically an open amount for an unspecified period of time. Rehabilitative alimony is related to helping someone become financially rehabilitated so that they can support themselves. Limited duration alimony, which is probably now our most common, which is a defined amount of time, an amount of alimony for a defined amount of time. And reimbursement alimony, which is very, very rare, which is usually tied to when somebody supported another spouse and paid money to help them become educated, say they went to medical school or law school or some other type of professional education, and then we're expecting basically like a return on that investment. That's what reimbursement alimony is. If you're going to be talking about those kinds of alimony, in particular rehabilitative or reimbursement, I think it's important that you really dive into the statute and some case law and understand what they mean. But for the most part, most people are dealing with open durational alimony or limited duration alimony. And if you look at the statutes, the statutory factors, the statute focuses on the circumstances of the parties, their need and their ability to pay. So what does that mean? That's what's the budgetary expenses on a monthly basis. And the ability to pay is what's the income coming into the family from all sources. The duration is relevant to both the length of the alimony, but also how much. Age, physical, emotional health of the parties. If you have a specific circumstance where one party is substantially older than another, or one person has health issues, that might come into play. And then number 4 is the standard of living that was established during the marriage. The other ones are also very important: earning capacities, educational levels, vocational skills, employability, the length of absence from a job market for the spouse who's seeking alimony, parental responsibilities for the children. It's very, sometimes very difficult if you have young children at home. You've got to balance parental responsibilities with childcare. There may be some special needs, some other things. And I'm not going to go through the rest of them. There's a number of others. You see, there's 14 factors. So it's very important that you understand these factors, that you read them, that you, if you don't understand them, ask questions, call a lawyer and ask some questions about what they mean. If you want to do some reading about some case law, that could help too. It's unusual that all of the factors come into play, but for the for the most part, usually the factors that come into play are needs, ability to pay. Really, the first 4 factors come into play. None of these factors are more important or less important than the others. They all carry basically equal weight, so to speak, but it all depends on the circumstances of the particular situation. I want to just focus for a minute also on 9 and 10. The history of financial and non-financial contributions to the marriage are very important. Traditionally, way back in the day, in my parents' era, men worked, women stayed home and took care of their children. The moms took care of the house and the kids, and dads went out and worked. Obviously, that's not the same circumstance that we have today. But the law basically presumes, in many respects, that both parents are making financial and non-financial contributions to the marriage if they're both working. If they're not both working, the law doesn't necessarily say that the financial contributions are any more important than the non-financial contributions. They're sort of in what we call equipoise in the law. They're similar, but it's important that it's recognized that both spouses tend to be considered to be making those kind of contributions. And then the other one is the equitable distribution. So in most circumstances, we're dealing with average people who have average income, assets and things like that, a house, 401ks, some retirement, other things. But when you get into some high income cases, you might be looking at what the assets that are being divided are going to be spinning off in terms of income, interest income. Oops, sorry about that. That is my timer telling me I'm 8 minutes in. So you want to look at that. For example, I'm mediating with a couple right now. They're going to split up about $4.5 million in assets. Of that $4.5 million in assets, probably 2 million are going to spin off some interest income on an annual basis. And that interest income can be looked at and considered in the discussions about alimony. So I gave you a very, very brief overview of the Alimony Statute, and I'm going to at some point put my email address in the chat box so everybody can have it. And if you ever have any questions, you can feel free to reach out to me. I'm happy to give you some information. I would suggest, if you don't have a lot of experience dealing with alimony, that you strongly consider going to some seminars that talk about alimony, so you have a good understanding of the statute and how it's applied. Roseanne, you want to add anything before I move on to child support?
No, that was perfect.
Oh, well, thank you. Okay, and again, we're going to take questions at the end. So if you have questions, feel free to put them in the question and answer Q&A box. So let's see if I can make this work again. You should now be seeing my my statutory factors for child support. What you'll see is that they're very similar in terms of what the law looks at. The needs of the child. Are there special needs of the child? And when we talk about needs, keep in mind that children need to have a room to sleep in and a bed to sleep in, and they need to have clothes, and they need to have food put on the table, and they need to have their medical expenses paid for. But need is a relative term, and so a lot of need is also related to the second factor, which is the standard of living and the economic circumstances of each parent. The needs of a child whose parents make between them $50,000 or $60,000 a year in gross income are very different than the needs of a child whose parents make $500,000 to $600,000 a year of income. That's just a fact of life. So when you're looking at child support, aside from dealing with the guidelines, which we're going to talk about in a second, the statutory factors should be looked at. You should look at what the needs of the child are, what the standard of living is, what the economic circumstances of the parents are, what their earning abilities are, what their sources of income and assets are. I'm dealing with one right now where mom has a trust fund that she is drawing $20,000 a month from. She doesn't work, but she's drawing from a trust fund, and that's how she's supporting herself and her kids. And those are sources of income that have to be taken into consideration when we're talking about child support. And then there's some other factors. Again, I'm not going to go through them in that much detail because I don't know that it makes a lot of sense to do that. Again, I think it's important that you read the statute, that you understand it. If you don't, ask the questions. Take a couple of webinars or seminars about it. But what's important to know about the alimony, about the child support. Oh, sorry. I'll just do that. The statute for child support is NJSA 2A: 34-23, and there's actually more to it. I will get it for you. The important thing to know about child support is that both parents have an affirmative obligation to support their children in New Jersey. And so both parents are, unless there's a reason why they're not able to work, are going to have income imputed to them at a level that is commensurate with the history of their earnings or their earning capacity, their education, and the like. Even a parent who hasn't worked in 10 years is likely going to be imputed some type of full-time income if his or her children are in school full-time for the most part, and there's no need for full-time childcare. Parents are going to be expected to go out and work and earn a living and contribute to their children's support. So that's a little bit about the statute. The guidelines were promulgated by the Supreme Court of New Jersey. They are relevant to most families in the state of New Jersey, and in particular go up to $186,000 a year of net income between the parties. I think the weekly is $3,460. Don't quote me on that, but I think that's about right. So if you have people who have more than that, the guidelines apply to a certain extent, but then you have to supplement the guidelines considering the high income. But we're going to just talk for a few minutes about the guidelines themselves, and I don't want to take too much time explaining how they work. The important thing is, if you're going to use the guidelines in your practice, in your mediation practice, you should buy a software program that helps you. They're very easy to use. They're very user-friendly. It's really very much an income-based formula. So you have to plug in incomes of the parties. You tell the program what kind of a parenting schedule they're going to have, and it will calculate the child support for you. Obviously, it's important that you put the right data in and that you understand how to use these programs. There are a number of child support guidelines programs that are approved in New Jersey for use. The one that a lot of my colleagues use, and I think is probably the one that most people I know use, is called Family Law Software. They have a scaled down version of their full robust program that is can be used by mediators. It costs $29.95 a month. I was because I know Mark Rogers from Family Law Software. He's asked me to tell you all that if you contact him, and I'll give you his contact information, he will waive the $99 setup fee for any mediators that want to purchase this program. And he also, one of the nice things about Mark is he will give you a tutorial. He will show you how to use the program. He will answer your questions. There's also a more robust version of that Family Law Software program and some of these others that will help you with alimony and other types of equitable distribution. There's all kinds of features. They're more expensive. I find them very helpful, but that would be another hour or 2 hour webinar to start getting into it. There are some other excellent programs out there. One is called Custody Exchange, which is custody, C-U-S-T-O-D-Y, the letter X, and then the word change. I believe that is that program is put out by a company called EasySoft, which was the one of the premier CIS programs or child support programs in the state for a number of years. There's a program called DivorceWare NJ. There's one called divorcehq.com, and the state actually has a calculator called NJChildSupport.org. I will put all of these in the chat box while Roseanne's speaking, so everybody can have them. They range in price, but I highly recommend, if you're going to use child support guidelines, that you buy one of these programs and really get to know it and understand how to use it, so that you can calculate child support by the guidelines. At some point in time, we're going to talk about how we use them and why we use them or don't use them. I think Roseanne's going to talk a little bit more about that when she speaks. I do use them quite often because I'm trained. It's just part of my training that just so happens, but I don't have to. So with that, I'm going to turn it over to Roseanne, unless Roseanne, you want to add anything to what I just said about the child supporter guidelines.
The only thing I want to mention about all of the software is that depending upon what kind of device you're working on. So I work on a Mac. So for me, I also use the family law software. So you need to be really careful because a lot of these other softwares don't actually support a Mac. So that's just something that you have to keep in mind. but they are. It's really useful to have them. It's good to be able to even go back and compare to them, even if you don't use them, just become familiar with them. You get a lot of information off of it. So thanks, Bruce.
Thank you. You're up.
So I want to explain to you today how I walk my clients through and am able to get them to come to agreement on spousal support and child support. I basically, in my initial consultation, I always let the clients know that, there are child support guidelines that the courts put out, and I explain that, it's basically a calculator where you're entering in incomes, you're entering in overnights, who's paying for healthcare, but basically that it really, in my opinion, doesn't cover all of the expenses that you go through when you're raising children, especially in the area that we're living in, right? Kids need, like Bruce said, more than just food, shelter, and health insurance. So same thing with spousal support. When I'm talking about spousal support and explaining, I explain that there really are no guidelines, exactly what Bruce said. And I think that this is one of those areas where your clients are going to come in and they're going to think they've gained some education by talking to people, and you hear so many different things. So right off the bat, I always explain that the way that I approach these two is based upon need, lifestyle, incomes, and what the practice of the household has been. So in part of my mediation process, I do have couples fill out extremely detailed budgets. And if you go to and you have the software for child support, there is one screen that actually will build out for you what are those everyday expenses, monthly expenses that should be included in a budget. I find that this information for clients is invaluable. Most people have no idea how much money they're spending monthly. So the way that I approach, and I'm going to speak to spousal support first, is that I will send them. I've actually generated my own budget sheet where I have calculations. I send it in a PDF because I'm not going to sit down and check everybody's formulas, but I basically send it to them well in advance of our session where we're going to be talking about spousal support. And I get them, and many times couples will actually go through this and work together. And I have both clients fill it out. It doesn't matter who's receiving and who's paying, because in my opinion, we need to make sure there's enough income to cover everybody's expenses. And then of course, also the children's expense. So at the same time they're doing their budgets, they're doing a budget for their kids. So when they come to session and we start the conversation, I start it by going through, and a lot of time people need help with it. But really what it's doing is it's reinforcing what the practice has been, what the need is, but it's also reinforcing where you're getting the couples to kind of work together. Because I think that the most important thing is that they're in agreement that yes, this is the budget. Sometimes you'll have people who try to increase some things and want to inflate what spousal support is going to be. And that's very easy to check. So then we have some statements pulled, bank statements, to really understand what has the practice been. And at the end of the budget and doing their budgets, it becomes clear as day as to where the need is and how much the need is. But I always preface before I start that session by explaining, understand whatever that bottom line number is. And if there's a deficit, I'm not saying that entire deficit has to be covered by support, okay? Because sometimes it's unrealistic or there's just not enough. So at that point, after the clients are educated and we see what the need is, then it really becomes a negotiation. Then we're looking at, has somebody been out of the workforce? Basically, all of the statutes that Bruce went over, we're taking into consideration, but we're doing it in a very realistic way. I always tell clients the last thing I want to happen when they leave mediation and they're divorced is to be up against something where somebody can't afford to either live or maintain a lifestyle, so to speak, or be able to take care of their kids. So that's how we come to agreement on the spousal support. When it comes to child support, and Carl had just asked me when we were just prepping for this, what are the percentage of your clients that want to use the court calculator? I probably have 2% of clients that want to use it. I explain that it's there, but most time couples are in agreement to really understand what the need is. The only time I have to say that I will encourage that we use the child support guidelines is either when there's very little income and the parents really don't have enough income to cover certain things that they'd like to do, so we really get an understanding, or other times clients will want to kind of do the comparison. So I always leave that open to them, but like I said, most of the time we're going through a budget. So we're establishing, the first thing I do after we go through the budget for the children is that we establish, how much parenting time does each parent have? And then we'll go through the practice of saying, okay, what will each one of you be responsible for? What are the costs that you'll each be responsible for during your parenting time? And this is where you really kind of get a picture into how the family has lived, their lifestyle. Some couples will say it's just really going to be food, shelter, and toiletries. And then I have other couples who maybe want to add in certain things. Maybe it's clothing, it's everyday clothing and things like that. So we'll establish that. Sometimes it comes into where one will pay the other for these basics if there is this difference in incomes. But then also what we're doing is we're creating a budget for what I call these expenses that kind of pop in and out of the children's lives. Sometimes when they're young, you'll have to pay childcare. As they get older, you're paying for sports. It may be camps. So we developed this budget that, as Bruce mentioned, is joint because both parents have the responsibility for contributing to their children's living expenses. Most of the couples that I'm working with will agree to a basic budget and then agree that they're each going to contribute X amount. The amounts that they're contributing is usually based upon their incomes and a percentage share of their combined income, so that one parent doesn't carry more of a financial burden than the other. And also what parents agree to is that they're going to go through and review these budgets every so often and make changes as need be. Because I think that's very important because it also affects each one of their cash flows. So I do spend a lot of time with clients so they're understanding, and you basically will find that one client, is the one who's been leading the financial decisions, maybe paying all the bills, and it really becomes an education for the other one also. And what I find is that it empowers them. It empowers them to understand what's going on, but it's also empowering them to make those decisions. So that's my basic approach. I think that it works for me. It works very well. My clients are happy to go through it. Like I said, it's an eye-opening experience for most of them because most of them don't realize how much money they're spending on Starbucks every week. So, and we can kind of go through and I pull it up on my computer and I use it as a working session. So sometimes, I explain to them that of course there's a greater expense for two people living apart than living together. So sometimes we have to tweak the budgets and they themselves will agree, well, okay, you know what? I don't need that much money for entertainment every month, or we need to cut down on the vacation spending and things like that. So it really gets them working together and coming to agreement. Bruce, did you have anything? Did I miss anything?
No, thank you. I will, again, anybody has any questions, put them in the Q&A. I want to just highlight a few things that Roseanne talked about and talk about the way that I do it. We do it very similarly. I think it's important to have the couple provide some type of a joint marital budget. I don't even like calling it budgets anymore because budgets are money coming in, money going out. I want them to tell me what their monthly expenses have been. What do they spend their money on? It's hard for a lot of people to do because they don't keep track of it. Many people don't. So they need to go into their credit card bills and credit card statements, their bank statements, and look to see what they spend their money on. And when they tell me that they, take a few $100s a month out in cash at the ATM and that's what they spend, I suggest to them that they might think about what they spend their money on when they take the cash out, and where that money goes. But I also then ask them to create anticipated budgets going forward. How much are they going to be spending when they are living separate and apart from each other? And that's a bit of a balancing act too, because they have to figure out which of the kids' expenses each of them are going to pay. Obviously, if they're sharing parenting time with the kids in any meaningful way, they're both going to have food expenses and toiletries and all kinds of other expenses related to the kids when they're living with them. And then you have the other things, like it's not always necessary for both parents to buy all the clothing for the kids. Obviously, shoes should be, are not necessarily one house or the other. They're both. Outerwear, hats, coats, gloves, things like that. So sometimes you have to work with them to get to a point where they understand that. And it's hard for people to separate their expenses from their kids' expenses, but it's not impossible. What I generally ask people to do is to look at it from a holistic perspective. How much do they need on a monthly budget to go forward, on a monthly basis to go forward? How much money do they need to spend on themselves and their children going forward? And then they bring that to the table and they tell me, here's what my budget looks like. And I try not to let people pick at each other's budgets and say, well, she's going to spend what on clothing? That's way too much money. And she says, well, he's going to spend what on sporting events? No, that's way too much money. Golf, right, exactly. And to just come to the table with a number. And then I look at that number, and then I find we talk about how much money's coming into the how much money's coming into the business, into the family, where it's coming from. What does it look like from a net dollars standpoint? And then we look to see, like Roseanne said, is there going to be enough? Are they going to be able to meet their budgets going forward? If they're going to, then it's a matter of how do we shift money so that everybody can get to their budget if we can, if there's enough. And if not, then we have to look to see how much of a deficit is there and where do we apply that deficit? And that then, sorry, go ahead, Roseanne. Go ahead.
No, I failed to mention that, basically the example I'm giving is basically 2 W-2 earner incomes or one, okay? When you're dealing with the business owner, that looks very different, okay? Because as business owners, they can write off certain household expenses, personal expenses. So that is often the time that I encourage that we bring in a neutral third-party financial expert. Usually I have a CPA that I work with in these types of cases because it's not cut and dry. And that's where you have to have a little bit more, I'm going to say, confidence and ease in dealing with those types of issues. So I will bring in somebody and bring in an expert so we truly understand what is the available income, because so many times business owners may take all of their extra profits and stick them into a SEP and save more money, but there could be more available income coming in. So I just wanted to explain that, Bruce, that when we're talking about this, we're talking about W-2, you're looking at their paychecks, you know what's coming out for healthcare, you know what's coming out for 401k, and you know what's coming out in taxes.
Right. So I like Roseanne, I approach it from these 2 different aspects. I need to know how much they need to spend to live a reasonable lifestyle going forward. And I need to know how much money's coming in and where that money is coming in from. And then we try to balance it and see what makes sense. I've dealt with couples who are both coming to the table with budgets that are, already in deficit. They're $1,000 a month easily or more at a deficit situation based on how much money's coming in the door. And then we look at their budgets, then we have to start looking at the detail and say, where can everybody move a little bit? Where can everybody save a little bit in their budget? What can they change? Can they change their vacation budget? Can they change their car expenses? Can they change their choice of, how much they're spending in cable and internet per month? Oops, sorry. Can they change, other things that other expenses that are discretionary? Can they reduce their restaurant budget? Things like that. But also to try to find some fairness in terms of, is it fair if their budgets are relatively the same? Is it fair for one person to be $2,000 under budget, but the other person's only going to be $500 under budget? Or is it even fair for one person to be $2,000 under budget, the other person is flush or has a surplus? So I try to get people to look at it. I show them the numbers. I try to get them to look at it to try to figure out what looks fair to them in terms of how much they're both going to be looking at deficit-wise, and not necessarily even it out, but just try to make it look as fair or seem as fair as it possibly can.
Bruce, we have a number of Q&As. I just want to let you know. I don't know if you looked. Yeah, if you want to kind of start going through them, so we have enough time to answer.
Yep, I just want to mention one more thing, and then we're going to get to them. I, like Roseanne, engage experts in mediation when there's questions or concerns, or I think that somebody might not really understand it. Experts can be very helpful for me to understand things that may not be so simple. For example, income. People need to understand where their income's coming from, and experts can be helpful, especially if you have a person in a relationship who doesn't do it. One of my favorite stories is about my client who was a very, very successful physician. His wife was also a physician. They ran a practice together. My client knew nothing about their finances. And I hired an expert to dive in. And when we met with him and the expert told him how much money he makes in a year, he laughed at us and said, I don't make that kind of money. You're ridiculous. And then we told him how much they had in assets that they were dividing up. And he same thing. He couldn't believe it. He was like, no, you guys are way out of the range here. But he wasn't the one who was financially savvy in the relationship. His wife was extremely financially savvy. And then sometimes you have one of the partners who just never paid attention. It's not a bad thing. It's not a judgment. It's not a criticism. It's just that they never paid attention to it because they didn't have to. And now they need to. And sometimes that spouse needs some assistance. Sometimes they need some help, even privately, to understand the finances. So I will engage any experts we can in the process who are going to assist us. So let's get to the questions.
Let me ask a few questions.
Carl, before you ask a question, hold on. I just want to make sure everybody sees that I put a whole bunch of information in the chat box of the family law software offer that was made for mentioning them today, but also the other types of the other child support guideline options that are out there. I put in my email address for everybody. And the one question I want to make sure I answer for everybody was the child support statute number is the number that I gave, and the section is A to the child support statute. It's NJSA 2A:34-23A is the child support portion of that statute. All right, so Carl, go ahead.
Okay, so Bruce, you and I have talked about this many, many times, about rules of thumb. And, obviously, the court does not recognize rule of thumb. They can't use it. Judges can't use one in determining alimony. But here is my experience that when I came to the alimony point of the mediation, I would send the parties out to attorneys to get some advice on just alimony. That's if they hadn't already retained them. And I would tell them, this is what your attorney is likely to say with respect to alimony. And it would be something, I forget, 1/3 of the difference between the two, right? I never had a couple come back and tell me that their review attorney said, I can't do that. I can't give you a number until we have a full discussion on all the statutory factors. Never happened once. So it may not be accepted by the court, but I would say almost every practitioner, lawyer practitioner, will use what's now a different prevailing rule of thumb when they're giving advice to their clients. Now, would you agree with that?
Yes, I would agree with that.
Okay, thank you. So now let me go to a couple other things. Roseanne, you said a very low percentage of your customers use the child support guidelines. Do you also run the child support guidelines for them?
If they want me to.
Okay.
I always tell them I have the availability. So I know that one of the questions was somebody was asking, why don't I just attach them?
Right.
Because I'm what I call a purist. I truly like to mediate in the way that clients want to get through their divorce. So if they don't ask to see guidelines, I don't run them. And if they need to be attached for the filing, that's left up to the attorney who's doing the filing. But in my MOU, I put extremely detailed information with how the clients are going to handle it. And sometimes I attach that budget sheet as the guidelines, because if they're going to change for the shared expenses, they have that example and that's how they can move forward with it.
Okay, Bruce, same question.
Yes.
What percentage of your clients use child support guidelines?
I would say most of my clients want to know the guidelines. I'm not saying they all use it, but most of them want to know what the guidelines are. Many of my clients, I would say again, most come in knowing that there are guidelines out there. In fact, they asked me about the alimony guidelines, which is how we get into a discussion about rules of thumb. Okay. So yeah, most of my clients use them now. Sometimes they don't want to. Sometimes they want to approach the alimony and child support from a different perspective. Sometimes they want to know. Sometimes they want to compare what they're doing in terms of budgets and incomes and money allocation versus what the guidelines say.
Okay.
One of the places where it becomes, sort of problematic is when people are tying custody and parenting time issues to child support issues. And that's when I try to wrench them away from using the guidelines, because that's when people start to argue about, 3 overnights a week versus 3.5 overnights a week. Do they go into a shared worksheet or a 50-50 worksheet, or are they in a sole worksheet? And the child support numbers change so dramatically sometimes. And that's when I try to keep them away from the guidelines.
Okay. When you run both the guidelines and child support according to budgets, how closely do they correlate in your experience?
I don't know. I'm not sure I have an answer to that. I think sometimes they come out pretty close, but occasionally they don't. I mean, I will say this, I do a lot more these days, higher income cases where the guidelines just are only applicable up to a certain extent anyway, and they're supplementing with additional child support. But I think they're helpful. I think they're helpful in guiding people to a resolution. So, you know, do they come out about the same? I honestly don't know the answer. I don't have an answer. Sorry.
Okay.
It's a lawyer answer for you.
I've talked to a number of financial professionals, and the view of quite a few of them is that when you're looking at alimony and the amount of money, that generally you're going to have a substantial deficit between what's coming in and what's available, because now there are two separate residences, and probably you're going to add something like in the area of $30,000 a year in expense that you didn't have before. And if you were living up, you know, spending everything you were living, this is a real problem.
Right.
Or better yet, living on credit cards.
Yes.
That becomes a nightmare.
Or when parents are supplementing lifestyle and the parents are going, now only going to supplement the lifestyle of one instead of both.
And the view expressed by a number of them is it's really futile to try to go over a budget to eliminate that kind of a deficit, because so much of what's in budgets are desires rather than needs.
Right.
And trying to say, okay, you cut down this part or cut down that part is sort of, it's really difficult. And if they just had a lump sum, they knew what they were living on, they make their own adjustments. They, you know, whatever they want to do. Maybe for a woman, it's much more expensive to spend money on hair.
Yeah.
And for a man, it's more expensive, more desirable to spend it on golf. I don't know, whatever it is. But they're all personal choices. How do you feel about that?
Are you asking me or Roseanne?
Okay, Bruce, I'll start with you.
You know, again, I try to keep people from nitpicking at each other's budgets, because it generally takes us into a rabbit hole and it's hard to get out of. Sometimes it's necessary because of the deficit. But I try to look at it from a more global perspective. If I see something really, you know, outrageous in a budget, I might raise it and say, you know, ask a nice question about what is that, you know. But I actually find in my mediation practice, people are much more realistic about budgets going forward than they were in my litigation practice. And mostly because these are people in mediation who want to work together and find a resolution and aren't looking to necessarily, you know, get a leg up on the other person. I see Roseanne shaking her head.
Yeah. Yeah. No, I don't experience that much where couples are not in agreement on their budgets. We're looking at the marital budget, and then we're looking at their separate, kind of, you know, peeking into the future. And for the most part, they're coming to agreement, and they're agreeing that the expenses that are showing on the budget are accurate.
Oh, yeah, I'm sure they're accurate as projections. The problem is there isn't enough money to cover them. Right.
No, I mean, that's the hard part. When there's when there's
definitely.
not enough money, and oftentimes when there's not enough money, when there's really not enough money, you're learning that people are living either from help from families or credit card debt. They're just, you know, racking up the credit card bills, and you know, there's what can you do with that? You really can't do anything with that, except sometimes I will refer them to a bankruptcy attorney, because sometimes there's just no way out. But, you know, those, I have to say, again, in the mediations that I do, those are the rare cases. Like Bruce, I mediate mostly people with, you know, decent, good amount of incomes. So we're not really running up against that too much.
Yeah.
Okay, with that, let's turn to the Q&A first. There have been hands raised too. Bruce, do you want to?
Sure.
field those, or-
So
Yeah.
Roseanne, the first question that was asked was, you indicated that you prepare a budget for child support, but don't use the guidelines often. Aren't the guideline worksheets required for filing a CIS? And why not run the guidelines as well as prepare a budget for the children?
Right. So again, I'm a professional mediator, not an attorney. So I prepare an MOU and my clients then go on to the attorneys for the filing or their review attorneys. So I've never had ever in my 12, 13 years of mediating an attorney come back and ask me for any information. It's all there in the MOU with how we've come to the agreement on what they've come to. So that's why I don't do that.
And a CIS is not, if you have a settled case with a marital settlement agreement, a CIS is not required to be filed with the court. Some counties require you file a child support guidelines worksheet, whether you're following the guidelines or not. Some counties don't. I can tell you, I've only been asked, I think, twice to provide child support worksheets in cases that were settled. When they're using the guidelines, yes, we attach them, but I've only been asked twice to attach guidelines when the case was settled and they weren't using it. Let's go. There's a question about duration of alimony. People tend to think they're married over 20 years, they're eligible to receive alimony for life. The answer is that the statute was changed in 2014. The legislature did away with what was used to be called permanent alimony, which was often thought of as lifetime alimony. There is no such thing in New Jersey. There is open durational alimony, which means it's an open duration. We don't know the end. The end will come eventually when there's been a substantial change in circumstances, when the payor retires at or after age 67, if the payor becomes disabled, obviously, if there's a remarriage, if there's cohabitation, there's all kinds of circumstances. But a lot of times I do have to disavow people of the notion that they're getting lifetime alimony. It just doesn't exist. Roseanne, you want to add anything to that?
No, I basically, most of my couples who have had 20 years or more, it's usually until they retire.
Yep. All right, we're going to try to do this in rapid fire because we're running out of time. Do courts provide some type of guidance with respect to amount and duration of alimony and the application of child support guidelines above the cap? There are cases, there are some cases out there that talk about it, but there really isn't a lot of guidance. It really is a matter of looking at what the lifestyle is, what the expenses are going to be going forward, and what the income is that's coming in and what's needed. There's a famous case about I think it was Michael Strahan's case about how much is enough. And then a lot of judges talk about how many ponies do you really need? Is one enough, or do you have to have 3 ponies? And so it really depends on the couple and the circumstances and the finances. People argue about what kind of car they're going to buy their kids, and how that should be calculated into the whole grand scheme of things. Does a 17-year-old need a $50,000 BMW, or should they be driving a $20,000 or $25,000 Hyundai or Kia? Those kind of things. So, and it does vary by county, and I have never had a couple come back to me and tell me that the court did not approve their settlement. Courts do not approve settlements. No. The court doesn't look at the settlement and decide whether the court thinks it's fair or equitable. The court only decides whether the couple entered into the agreement voluntarily, knowingly, of their own free will. I'm going to skip, Diana, your specific question because I think it's too specific for this, but if you want to talk about it offline, feel free. So Shakira asked, if the calculation states something by statute, can the non-custodial parent and the custodial parent come to another number? Absolutely. The court doesn't care. If they agree, the most important thing is that their agreement needs to explain why they're doing something outside the guidelines. Where did I?
Bruce, go ahead.
Okay, I'm being told that, oh, sorry, go ahead. I was going to go on to the next one, so go ahead and finish that
No,
one.
no. And I was going to say that for me, that's something that I love telling clients. I always tell them what people don't realize is you can do anything you want to in your divorce settlement as long as you both agree and as long as you're not breaking the law. And that again is really when people come together and will work together.
There was a question about where I put the information about the statute. They're telling me the chat is disabled. Carl, I'm not sure where else I can put it other than the chat. So
I can see the chat. The chat's in there.
I can see it too, so I don't know.
All right.
I don't know what that problem is.
Anju asked the question, when I'm the review attorney, will I look at the alimony provided and would I test it against the rule of thumb to protect myself? I do not. There's a lot of lawyers that think I'm crazy that I don't. I don't do it because I just don't believe that the rules of thumb exist in the law. I look at the case from the same perspective. First of all, if my client is okay with the numbers, I'll explain to them that number may not be the number they get from the court, that the court may go about it from a very different, with a very different number, a very different duration. So I'll have a very open, frank conversation with my client about what they need, what they want, what they think is fair, what they think is appropriate, and explain to the client that there may be, there may be circumstances where they might have gotten more, or they might have been able to get more, but I don't specifically calculate it based on a rule of thumb.
Bruce, there is a case where an attorney was found liable for not informing his or her client about the rule of thumb calculation.
So that was, by the way, that was from prior to the change in the alimony statute, in the tax code. And I'm Anju, thank you. Anju put it into the Q&A. That case was Leslie Smith versus Bet Grayson. I understand that.
Okay.
I leave it to attorneys to decide for themselves what they need to do in reviewing. As a mediator, I don't think I'm required to do that. Certainly don't think I'm required to do that as a mediator.
Okay.
So let's see. How do we address length of time for alimony? I don't know that I have a good, easy answer to that one. I talk to people about where do they get these, amount of years of alimony from? What's the basis of it? Why do they need alimony for 5 years versus 7 years versus 10 years? I will tell you, a lot of my clients come to the table thinking that alimony should be 50% of the length of the marriage, because that's the rule of thumb that's out there that people think is what it is. But that I just talk about it. Roseanne?
Same thing. I talk about the need. How long is the need? Sometimes people they get into the length of the marriage. Sometimes they'll go, and of course they have consults with attorneys, and the attorneys will stick a number in their head, and that's kind of where they start. But everything then gets negotiated. Right.
So Carl, I know we're running out of time. There were 3 people who had their hands raised. I don't know if we have time to.
Yeah, let's try that anyway.
Okay. So I'm going to Michelle Barr. I just gave you permission.
Muted.
Just unmute yourself, Elle, and talk.
I'm so sorry. I'm not sure how my hand got clicked. That was an error. I apologize.
Okay. Thank you.
Okay, that's
So
good.
let's Jan Cato.
Yeah, Jan.
There you go, Jan.
Hi, I think you already answered my question.
Okay. Terrific.
Good.
And how about Heidi?
Yeah.
Oops.
Likewise, I did not raise my hand. So
Okay.
All right, and now we have one more, Diana.
Hi, everyone. I just wanted to double check. I have a mediation that's just tying up and the husband is very concerned. I may have missed the answer to this previously, that if he gets another job or has other income post-divorce, will his wife be, and the alimony need to be adjusted because he has more income coming in. I've explained that it's going to affect the child support. There are 4 children involved. But that's the question. If he should have an increase in income, does that affect the alimony? And I've explained that if there's a decrease, he can apply to the court. So what are your thoughts?
Well, I think any income coming in is a relevant conversation. I would talk about whether he should be required to work a second job in order to be able to pay the alimony. And so that leads to a conversation with people about what's a reasonable expectation, and should somebody have to go out and get a second job in order to be able to pay to support the other parent. I think it depends on the circumstances. I don't think he can avoid the conversation, though. If he's going out there and getting a second job and everybody knows it, there has to be some conversation about it. You know, I think one of the things that happens, Diana, is that people want an easy answer to these questions, and there's just not an easy answer to it.
Okay.
And really what it comes down to, Diana, is what they deem to be fair. So I might counteract that, and I might say, okay, well, that brings up a good point. So if one of you wins lotto after you're divorced and you're getting millions, should that need to be shared? You know, and just kind of start the conversation, and you'll learn kind of how they're thinking and what their feeling is. So other couples that I've had in those situations, they've come to the agreement that maybe that parent is going to contribute more to a college fund. So the kids will be the beneficiary, as long as, of course, the spouse has enough to live.
I thought the general rule was, in fact, the law, that if, for example, the couple had a marital lifestyle on a 7 out of a scale of 10, usually when you get divorced, your marital lifestyle goes down to, let's say, a 5. If the one party makes a lot more money, that the ones who's being supported had a right to go up to the marital lifestyle, up to the 7 again, but couldn't go above it. I thought that was, I forget the name of the case. Ring a bell? No.
Sorry, Carl, say it one more time.
Okay. That essentially the person who is being supported, getting alimony, has a right, if there's an increase in the income by the payor, to get back up to the marital lifestyle, not above it, but up to it.
Right. That's part of the conversation. But is a second job and that income part of the marital lifestyle?
Well, couldn't it also be, you know, the receiving spouse of the alimony goes, you know, gets skills and suddenly can make a lot more money in their job. So it really depends both ways,
right,
as to, you know, who is getting the additional, and we're talking about substantial changes in alimony and in income, and how does it affect the alimony that's being given. So, you know, you're saying, I like your idea about agreeing to go to college or putting it in some spot. But, you know, what I've told the clients is that if there is a large change and it can't be resolved between you, then it's a matter of, once again, trying to see if it's applicable to file a motion.
And keep in mind, Carl, that lifestyle is not necessarily just monetary. Lifestyle is not just about what they spent and what they earned. It's also about how they lived. So did somebody have more than one job during the lifestyle, during the marriage? Savings is like the big, you know, issue that goes, was savings a component of the marriage? if savings was a component of the marriage, then it should be part of the lifestyle going forward.
It is.
Those kind of things. I'm just saying that
That's-
when we're looking at lifestyle, it's not just a monetary, you know, you have to look at like at the, you know, at who they are, what they did.
Okay.
So I think that the job issue is a really big one, because if somebody worked, you know, if somebody typically worked 70, 80 hours a week at 2 jobs during the marriage, that's part of the lifestyle of the marriage.
Right. Okay, I think we have concluded, because we're a little bit over time. I want to thank both of you very much. We had excellent attendance today and really good questions. I just want to make a couple of announcements. Next week, on Monday, we have a webinar, which is a mock divorce mediation. And Anju will be the mediator, and we will have 2 guest parties, and it's going to be a same-sex mediation, divorce mediation. Little preview as to what's happening in the fall. The next season of webinars starts in September. There's going to be a CLE series just like this year. There will be 9 CLE webinars, generally on the first Monday of each month. The cost will be $90. It will not be credited against the annual conference, but that's really cheap, $10 for a CLE seminar. Some of the subjects are September, we're going to have one on body language and micro expressions. In October, mediation techniques on the civil side. November, pension plans, quadros, and pension valuations. In December, we're going to have imbalance of power and mediator neutrality. How do they play together? And in January, we're going to have a repeat with Kim Ringer and I on ethics. And then we have a few more to be decided yet. But those are the CLE seminars. We're going to continue to have the mock civil mediations, the mock divorce mediations, tech time with Lawrence and Carl. So we're going to have a really busy webinar season starting in September and ending next May. So with that, thank you for an excellent attendance today. Really great presentations. Thank you very much.
Thank you.
Thank you.